Welcome to the Law Awareness Weeks at CDC 2025. This webinar is part of Law Awareness Weeks at CDC 2025. It is a collaboration between Pro Bono SG, the 5 Community Development Councils, National University of Singapore, Faculty of Law, Singapore University of Social Science School of Law, Singapore Management University School of Law, the Singapore Corporate Council Association Pro Bono Chapter, and Singapore Association of Social Workers, supported by the People's Association. I am Nadia Fernandopulle, and I'm your host for this webinar. Please note that today's discussion is not intended to substitute any form of professional legal advice. If you require specific legal advice, please consult a lawyer. With that, I would like to introduce our panelists for today's webinar. Ezra Bunyamin and Ustaz Mohammed Ridhwaan Radzi. Ezra is the Managing Director of Deansgate Barakah Law Corporation. He graduated with a Bachelor of Laws Honours from the University of Manchester in 2015. He also holds a Graduate Diploma in Social Psychology and Counselling and a Professional Diploma in Applied Psychology from the National University of Singapore. Ezra is also teaching as an Associate Faculty Member, Public Safety and Security Program at the Singapore University of Social Sciences, with a focus in Singapore legal system and criminological theories and intervention. Ridhwaan discovered his passion for Islamic finance in his pre-university studies at Madrasa Al Junaid in 2013. Since then, he has completed 3 certifications in Islamic finance, gained 3 Service Excellence Awards during his national service at SCDF, completed his business degree at Nanyang Technological University, spent 6 years in the financial space with ING Bank, OCBC Bank, Amani Advisors, Etika and others, and is currently taking his CFA certification. He co-founded Islamic Finance Singapore and RiskX, the former a WhatsApp group turned Syariah advisory firm, and the latter a local fintech platform supported by NUS, NTU, and SMU, allowing the community access to halal public and private investments. Ezra and Ridhwaan, thank you for joining us today. So we're going to move straight in and talk about the overview of Islamic inheritance laws. And I'll go directly to Ezra. As our legal expert on this panel, what is the difference between inheritance laws under Islamic principles as compared to civil probate laws in Singapore? And is it normal to have mandatory heirs and beneficiaries in most jurisdictions?
All right, so firstly, let us try to understand first what's Faraidh, right? So briefly, Faraidh is the Muslim law of inheritance as decreed in the Holy Quran. So more on the religious aspect of Faraidh and what it entails will be shared by my brother, Ustaz Ridhwaan, later on. Pursuant to Section 111 and Section 112 of the Administration of Muslim Law Act 1969, as can be seen on the slide on your screen, Faraidh is applicable whether or not a Muslim drafted a will or if he or she were to die intestate. Accordingly, the Intestate Succession Act 1967, so far as the distribution of the intestate estate is concerned, is not applicable to Muslims. So for example, for non-Muslims, generally, a typical family nucleus consisting of a spouse and children, the spouse gets half and the children receive half of the estate in equal shares if there's more than one child. And it doesn't matter the gender. It can be sons or daughters, but the share will be equal. However, for Muslims, considering the same makeup, the same family makeup, if the children are present, a surviving wife receives 1/8 of the estate and a husband receives 1/4. If there are no children, the husband receives half and the wife receives 1/4. Now, the drafting of a will of a Muslim who is domiciled in Singapore is subject to or limited to Faraidh and or the school of Muslim law he or she professes. This is pursuant to Section 111 of the Administration of the Muslim Law Act 1969. Now, the formality of drafting a Muslim will must still be in accordance to the formalities set out in the Wills Act 1838. Therefore, it must still be in writing, the testator must be of sound mind, and 2 witnesses above 21 who's, of course, also of sound mind, etc. Right? However, the drafting of a Muslim will must still be in accordance to Faraidh in relation to how the properties are to be disposed. A Muslim may only dispose no more than 1/3 of his or her entire estate to non-Faraidh beneficiaries only. Any Muslim's wills which gives or disposes beyond what is allowed according to Faraidh will be void. So, for example, a father who drafted his will and wishes to give equally to his sons and daughters. If such a will is drafted, then it will be considered as void because it is not in compliance with the Faraidh principles. Now, how can you determine what's the share and who are your Faraidh beneficiaries? So you may visit the Sharia court portal. Under the inheritance tab, you will see inheritance calculator. You need to provide as much information as you can in relation to your family tree, and the system will auto-compute the shares that each rightful Faraidh beneficiary will receive, as you can see from the next slide. As you can see from this slide, the son will usually get 2 parts compared to a daughter. So usually daughter will be 1 share and sons will be 2 shares.
So if I can just stop you there for a minute. You mentioned that you can't, in a will, so in Wasiat, right? You can't will anything to someone who already has rights under Faraidh. So what is your will, what can someone give in their will and to whom can they give it?
Right. So basically, a lot of people actually ask these questions, right? So, I mean, if you are still needing to follow and whatever we give, it must be still be in compliance with Faraidh principles, then what's the point of drafting a will if he or she is not able to dispose of his or her asset in a certain way? Now, the purpose of the will at the end of the day is for you to appoint an executor who will help to manage your entire estate. That's number one, right? That will actually decrease any acrimony between or amongst family members who are fighting for a right to administer the estate, right? So firstly. So secondly, you are still able to give 1/3 of your entire estate, no doubt, not to your Faraidh beneficiaries, but to non-Faraidh beneficiaries. So for some of my clients, what they do is they actually give it to their grandchildren who are not part of the rightful Faraidh beneficiaries.
Okay.
So that's one way of doing that, right?
So if we move on to Ridhwaan,
Yes.
there is some amount of planning that can be done before end of life, right? So could you please comment on whether the concept of planning end of life matters is consistent with Islamic teachings and principles?
Okay. Thank you so much, Nadia. First of all, thank you so much to Pro Bono for organizing this wonderful event. I feel like a politician. Looking at myself with the backdrop and all. So first and foremost, when it comes to Wakaf, Wasiat, and all the different inheritance tools, right? It is actually quite counterintuitive. Allow me to start with that. Why? Because when a person passes away, and this is also goes for when it comes to commercial transactions, when it goes for other kinds of rulings, how can a dead person make the transaction? Yes. So, but in Islam, it is permitted. And how is it permitted? Is through this wakaf, wasiya, which I will explain in the next few slides. Because Allah SWT has given a second opportunity for the person who is on his deathbed to make up for what he intends or he is repentful of. So that is very much why we have the different tools that we have when it comes to inheritance tools. So when it comes to the first instruction to bequeath, if I can just share, It actually is a process or a story. So there are 3 verses, and allow me to share. The first verse on the instruction to bequeath, kutiba alaikum idha hadara ahadakumul mautu, and all until the end. This one was the first verse that came when it comes to bequeathing for on your wealth. And there's no instruction to give will or instruction to do faraid or whatnot. Because at that time is people just left it to what they want, who they want, and usually they will leave it to their sons or those who they prefer. To their closest family member. And you can see that the Arabs did it already. They leave it to their sons or their those who love. But Islam came to refine this process. And this is shown in the next verse, wasiyah for the wife. وَالَّذِينَ يَتَوَفَّوْنَ مِنْكُمْ, and until the end. In times of Jahiliyyah, or in times when before Islam came, right? Women were deprived of a will. So, example, if a husband passes away, the wife will then just be ignored. So there is nothing to be left for her. And they have to remain. Allow me to rephrase. And when this instruction to bequeath came, the instruction was that you leave some asset for the wife after you pass away, and that asset that amount of wealth has to last for at least 1 year, so that the wife can stay at home for 1 whole year. But if you look at it another way, right? Islam came to abolish the ruling that there's nothing for the wife, or there's nothing for the female heirs. Okay, then we go to the third prescription of shares. That's where it gets a bit more detailed, and I think if you look into the different rulings, the different commercial transactions and whatnot, right? One of the more detailed aspects when it comes to Sharia rulings or Islamic rulings, right, is when it comes to Faraid. Why is it so? Is because if anyone can say, I leave it to 1/3 to this person, half to this one. But what if that is a divine ruling, or you have to give it this? You have to give it this amount to this amount to this amount to this rightful beneficiary. So then there is no qualms about it. So that is in a sense what the rationale for it. Okay, so this verse abrogates the previous ayat, where you have to leave something for your beneficiaries, you have to leave something for your wife. It basically abrogates and gives the rightful heirs to their rightful amount. And again, it's one of the most detailed verses in the Quran. But you also still need to do your wasiyah or your will, or because it's only the 2/3 of the amount, or the remaining estate, right, will be given for your faraid, whereas 1/3 will be given to whoever you want outside your beneficiary or faraid beneficiary, which I will explain later. Maybe it's a bit more not clear this time around, but I'll explain it later. Okay, now, if I can go on to the hadith on wasiyah, right? There is a call to plan early. So, if I can just share, when the Prophet Muhammad SAW said that a wise man is the one who calls himself to account and refrains from doing evil deeds and does noble deeds to benefit him after death. So, when he is still alive, he plans for after death, not that he plans just for the living, but also plans after his death. And my teacher, his name is Mufti Faraidh, he lives in the UK. His father said that I'm going to die this year. This is what you can find for those who are very spiritually grounded individuals. They know that, okay, this time round I'm going to pass away, or this year I'm going to pass away. But another, okay, that's actually a segue. When it comes to our community, you don't really feel the urge or the urgency. But then when it comes to COVID-19 or something, right, then you see, people start to want to do wills, want to do beneficiary allocation and whatnot. And even there's a story by Islamic finance guru in their book, Halal Investing for Beginners, where they said, in their taxi cab, there's a person who is going on the way to heart surgery. And then they say, hey, Ibrahim, the writer of the book, I want to do a will before I go to the operation room. So when you are about to pass away, then you plan. No, it's not the right method. So as what the Prophet Muhammad said, you should plan before you pass away. So plan not just for your living, but also for your next afterlife. Okay, and if I can move on to the urgency of wasiyah, right? This is Ibn Omar. Ibn Omar is, people may have heard of Omar. Omar is the second caliph in Islam. This is his son. So he is known to be someone who really loves the Prophet Muhammad Sallallahu Alaihi Wasallam, and even such that when he saw a tree where the Prophet would stay or would sit under, he just went there just to emulate or just to show his love for the Prophet. And if you have heard of the Maliki school of thought, Shafi'i, Hanafi, and whatnot, right? Maliki school of thought comes from him. Okay, but that one is just a background of him. Now, he mentions that it is the duty of a Muslim man, and he is narrating from the Prophet, who has something which is given as a bequest, not to have it for 2 nights without having his will regarding it. So this is what he got from the Prophet. So he was still alive, and when the Prophet was still alive, and he got, and when he was still very young to get this. Okay, but how does he, Ibn Umar, emulate this love or with this sayings of the Prophet? So we go on to the next urgency of wasiyah, where Umar mentioned, right, that ever since I've heard the Prophet Muhammad say this, which is just now, you don't live 2 nights without leaving a will, right? I have not spent a night without having my will returned along with me. So he didn't stay for 2 nights, rather he stayed for 1 night. So this is how much he loved the Prophet. So in retrospect, or for us as Muslims, right, to show our love as a sign of love for the Prophet Muhammad, this is one practice that we can do. Yes, we can do your sadaqah, you can do your charity, you can do your zakat and your prayers and whatnot. But this is also one practice that you can do to emulate or to show your love for the Prophet. But unfortunately, our Muslim community has not reached that level yet, if I may say so. And this is shown by data from in 2023, the Society for Trust and Estate Professionals found that 56% of adult Singaporeans have made a will, yet only 14% of them had one that was up to date. So this is perhaps a call from our the panel here, that if you haven't done your will, if you haven't done your estate planning, do so, and perhaps it will help you to plan early as well as to plan before you pass away. Okay, and if I may move on, right? Allow me to just move on. Okay, so this is more to the practical side, tools to distribute your estate when alive. So I got this perhaps a much easy way, perhaps I try for our community to see, okay, what can you do with your estate? So number one is you can do your hibah. Hibah is a gift when you're alive. So you can give anyone hibah, your son, your best friend, and your whoever lah you want. Okay, as long as it's a person. And then you can also do nomination. Number 2, nomination, insurance, as well as your CPF, so that when it comes to distributing it, you are able to distribute it easily or efficiently, as compared to if you don't have a nomination. Now, then you can thirdly do wakaf. Wakaf is something that you can is okay. There's a technical meaning to it, but wakaf, one aspect of it is you can do your wakaf to wakaf masyarakat Singapura or any other country like Wales. One example is in Medina in Saudi Arabia, right? There is a well by Uthman. Uthman is the 3rd caliph, and until now his well is still there. He's a wakaf for the community. So you can imagine the rewards that he has from the time he was alive until now. He gets a fixed income from the well. Then the 4th one is trust. So trust is, for example, if you want to leave for your child when he grows up to become to enter university, right? So that proceeds from the trust can be channeled to him to pay off his school loans or student loans or something. And then lastly, joint tenancy or joint account. So if you have a house and you want to do it for with your wife or something, right? Your joint account with your mother or sister. So when someone passes away out of the two, then the surviving will receive the remaining amount that is in the account. If I may move on to the rights attached to the estate. So just now you heard about the tools. So when you're alive, you can apply it. You can plan your estate properly. Now, what happens when you have passed away? So this one is, let's say you are, okay, no, this one you have passed away. So imagine we are looking at the future. So number 1, rights attached. So that one is, number 1 is your zakat, and then ar-rahnu. Ar-rahnu is a Islamic pawn shop. All right. So if you have your gold and you loan it, then you can have cash from it. So you have to pay back. Okay, zakat, of course, is your alms. Then secondly is your preparation for your burial expense. So usually people don't do this, and they leave it to the surviving beneficiaries to do it for them. But based on the tradition, Islamic tradition, we usually allocate some wealth for the burial expenses. And then thirdly, the debts due. Debts due, for example, your Hajj, as well as your debts to humans or your friends or something. And fourthly, your wasiyah. So your will. Okay, that one third of your wealth remaining after giving off your hibah and all and everything, right? Your debts and whatnot out of your wealth. Let's say it's we divide into three. One third of it is your will. You can give it to anyone outside of your beneficiary, your Faraidh beneficiary. Then lastly, the 2/3 is your Faraidh beneficiary, which is what Brother Ezra has mentioned earlier. Okay. Now, if I can move on, I know I'm talking a lot. So, of course, when I was at the Islamic Legacy Planning Village, I get passionate about this. Okay. Now, what to do next? Now, if you want to do what to do next, I have two things. Number one is that you just remember claw square, we call it. I stole it from another panel. C is CPF, L is LPA, A is AMD or ACP. AMD is Advanced Medical Directive, A is ACP is Advanced Care Planning, and then will, and then your wakaf. We add that panel will didn't add this, I add this, so I can have it trademark. Okay, but one last thing, not one last thing, second last thing, encourage the testator, the one drafting a will or wasiat, to write a personal letter, last letter to their living heirs. Okay, because then you just want your beneficiaries or the surviving family to not argue with one another. So that could be your last letter to them. Okay, or what the reminder or something. And maybe if I can move on to the last one, go to your financial advisor and lawyer if you are not aware or if you don't know how to distribute your asset. Okay, and what will they do? This is just a basic thing. Yeah, I wanted to go through this with Brother Ezra, but he was sick that day, so I went through with another person to ascertain is this correct or not. Okay, then he said, yeah, correct. Okay. Okay, number one, culminate all your assets. So just collate all your assets. Number two is that list the rightful heirs and your intended beneficiary. So besides your Faraidh beneficiary, right, who you want to give, your best friend, your pet or something, right? Number three is calculate the default option. So if there was no hibah, there was no wakaf, or there was no trust or whatever not, what will be the intended amount that they will get? Then number four, you set your risk mitigants. Okay, if you give this person this and if you give this person this, what might happen? So that's where the lawyers as well as the financial advisors can give advice on. Okay. Now, lastly, okay, sorry, I keep saying last, but this is the last. Okay, so just now I mentioned about wakaf. For Muslims, we believe that when you pass away, everything will cut off, right? Except for three things. One is a child that will pray for you. But one other thing that I can add on is that if you give something for Allah, then it will remain. And this is reflected in the story of Imam Malik. Remember the Maliki school of thought, right? He mentioned that ma kana lillahi fahuwa baq. Whatever is for Allah will remain. And this is reflected in his book. So he created a book called Al-Muwatta before one of the Sahih al-Bukhari, one of the most foremost sources of book of hadith. So this was the first book on hadith compilation. So until now we are still reading it. So this is a reflection of if you leave something for Allah and it will remain. Okay, so you can do your wakaf or you can do something that is for the community and then intentionally for Allah. Okay, thank you so much.
Thanks very much, Ridhwaan. That was very, 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 very detailed and very interesting. And I'm sure our listeners will definitely be taking away claw squared as something to help them. So actually, before we get on to more detail from on claw squared and from a legal point of view, the alternatives to Faraidh, there's actually a question, Ezra, for you off the back of one of the comments you made around wills. So we mentioned that you can use a will to give something to someone who's not covered by Faraidh. So your grandchildren you mentioned, but we've got a comment from a listener who's asking, what if the parents have died of that grandchild? Would that will then no longer be valid? So, and would that child then get all that was willed to them by the grandparents?
Right. So basically, the simple answer to this is it will not. I mean, it'll be void already, right? That's the reason why we will always need to inspect our will again once someone in our family tree pass away, right? And the calculation may change, and that's the reason why I've provided the link to the Sharia Court website for our audience to look through and try out, right? And put in as many and as much information as you can, and you will notice that when you remove someone, right, from the list that you have compiled in the inheritance calculator, there may be a change in terms of how each person's share is allocated, right? So that's the reason why the will it can never be a permanent thing, right? Sometimes because of circumstances and situations such as the passing of, in this example, the grandchild, right?
Yeah.
Yeah, then, you will have to, of course, amend and make a new will.
And if the parents have passed away, so the children of the person who's written the will.
Yeah, because they may, at the end of the day, become the rightful beneficiary, right, according to Faraidh. So because of that reason, then they will no longer be able to receive from that.
Right. Okay. And one follow-up question is, if someone hasn't left a will, does it all go into Faraidh, or what happens to that 1/3?
Then there's no 1/3 applicable in this case if there's no will, right? Because you can only dispose of 1/3 of your asset through a will. If it is not, then it will go by way of the intestacy.
Right. Okay. So then you just follow Faraidh 100%.
Yes, then you just follow Faraidh 100%, correct.
Great. Thank you so much. Let's move on to some alternative tools. Like Ridhwaan mentioned, clause squared. There are alternative tools that we can talk through. So maybe you can talk through some of those for us, Ezra. Which assets and properties are subject to these alternative tools, and what exceptions are there where we can't cover them in a will, or we can't cover them by Faraidh laws?
Right. So basically, all the deceased assets in his or her name at the point of death are subject to Faraidh. Say, for example, considering the kind of normal assets that we Singaporeans will usually have, right? HDB, for example. HDB, if it's in joint tenancy, then it won't form part of the Faraidh distribution. There is a fatwa by Muiz in 2019 confirming the same. Insurance, CPF, if nominated as well. Joint bank accounts as well. So the right of survivorship applies in those cases, and the survivor takes 100% of the assets held jointly with the deceased. Now, if the CPF, insurance are unnominated, or the HDB is bought by way or was bought by way of tenancy in common, then it will be subject to Faraidh distribution, but limited to his or her share of the flat per the tenancy in common. So parties will still need to apply for a grant of probate if there's a will, or a grant letters of administration if there's no will, and the applications are to be made in the family justice courts. So usually for Muslim estate, then there will be an additional step whereby we will need to apply to the Sharia court for the inheritance certificate.
Right. Okay. So with these, with the joint tenancy, could you, because you just mentioned two different ways in which you can hold your HDB, and that seems to be one of the popular questions here today. So if you hold it in joint tenancy, then when you pass away, the remaining owner will get 100%. But if you hold it in the other option that you were talking about previously, if one owner passes away, it goes into Faraidh, the percentage that is owned by the person who died. Is that correct?
Yes, that's right. So maybe just to give an example, right, for joint, for tenancy in common. Let's say, for example, a husband and wife, at the point of buying or purchasing the HDB flat, you have to go to HDB to sign all the sales agreement and all that, right? So the HDB officers will actually ask you whether you wish to hold the property in joint names or in tenancy in common. So if you need to flag that to the HDB officers. So if you are to flag that you wish to hold the properties according to tenancy in commons, then usually for husband and wife, they'll put it as 50% each. Now, if one of them pass away, what happens is that the property then will have to be sold off, and 50% of the deceased person's share will then be distributed according to Faraidh. Of course, the 50% from the other spouse, that is entirely his or her own share, which is not subject to Faraidh distribution.
Right. So what would you advise someone who has already done this? They've done it so that it ends up with 50% going into Faraidh and 50% being held by them. What can they do now As in, if they want to make that change to bring it back into joint, can they go make any changes?
They can. You can actually apply through HDB, right? And then once you arrange an appointment with HDB, I'm sure they'll be very happy to assist you over there, right? You can change the manner of holding at any point, but of course, both parties need to agree to any change in the manner of holding of the HDB flat.
Okay.
Yeah.
So we have a question for Ridhwaan, actually. Is it common for Muslims to give a lot of their assets away prior to death? So wakaf, essentially.
Okay, cool. Allow me to just mention the saying of the Prophet. If you have heard of the ruling of 1/3, it is actually based on the hadith where the Prophet Muhammad SAW said that 1/3 is too much. When someone or one of his companions was about to pass away, and he said, "Should I leave half or the whole of my wealth to charity or something, or to wasiyah?" Then the Prophet said, "Too much. And half, 1/3 is even too much, but 1/3 is okay." Now, then the Prophet Muhammad SAW mentioned that it is better for you to leave your beneficiaries in a wealthy state as compared to if you were to leave them in a poor state. So it is actually much better for you, first of all, to leave your beneficiaries in a wealthy state. Now, of course, you can say that it's good to leave for yourself in the hereafter, right? But I think number one is that you also need to think of, if you are in the hereafter, but your living or surviving beneficiaries argue, "Hey, I just now you do wakaf, right? Hey, this one wakaf is actually my property, so you don't want to." Okay. So you don't want to leave. Yes, you have passed away. Your transaction died already, but then your surviving spouse or your beneficiaries argue. Then it's not good. Not good for the community. Not good for the lawyers as well. Okay lah.
So I think you actually led on to the next point we were going to talk about, which are practical considerations and challenges that govern distribution of property, and some things that people should consider when they decide, "Oh, I want to give this as a gift. I want to leave this as a charitable donation." What are the things that people need to consider in those situations?
Okay, I understand. So number one is that I think, first of all, perhaps go to your lawyer as well as your financial advisor. Comment all your assets, and after that, who are your intended beneficiaries. Then after that, you work backwards. Okay, I want to leave. Let's say you have 4 children, and then 1 out of 4 of the children are is a female, or is a lady or daughter. So if you look at the Faraidh beneficiary, right, she won't get the equal share. She won't get the equal share to the brothers. Now, there is also a possibility that you can make an equal share for the daughter. And how can you do that? Yes, there is one ruling. It's tanazul, which basically means that the male beneficiaries will let go of their right to take half, or to take their allocated amount. Then they have equal share amongst themselves. Yes, that one is possible. But the other one is, you can do is through the Hibah, through the trust or something, like you allocate for that the daughter. Then perhaps if you have special needs children, right, then I think there's some steps. I'm not really aware, or I'm not really apt at that. But then, for example, if you have properties outside, or if you have investments outside, how do you want your beneficiaries to know of? So all of these mitigants or issues you need to lay out for your beneficiaries. And maybe the last letter, right? Last letter to your beneficiary will help tell them, "Hey, you have property in Dubai, yeah." Yeah. OG.
Thanks so much, Ridhwaan. Just on the trust piece, there's actually a question that's quite aligned to that, and maybe for Ezra to respond to. Can you appoint your family member as the trustee to administer the trust?
I mean, it's okay to appoint family members as your trustee, because when you are drafting a will, in fact, they are trustee, right? But the only issue is, what is it, or what are the properties that you are seeking for him to hold in trust, right? So, for example, I suppose the question was asked in the context of maybe perhaps HDB, right? So for HDB properties, you cannot put it on a trust. right? So it's against the law, it's in our statute, right? So you definitely cannot hold HDB properties on trust. You may, however, hold private properties on trust, but from my experience, I understand, and I saw the question as well, right? That it is very expensive. So there's really something for you to really consider if there's any other better ways to do this.
So
Go about it.
in that situation, would you say if you don't want to spend so much money, maybe looking at a joint ownership would be the way to go?
Yes, that's right.
Okay. I think we've got a lot of questions on the next topic that we're moving on to, which is lawful heirs and modern families. Because I think both Ezra and Ridhwaan have talked through Faraidh and who the lawful heirs are under Faraidh. But I know in the world we live in, there are mixed marriages, there are families that are from multiple spouses, and they may not all come from direct Islam following families. So, and also there could be adopted children as well. So in that situation, would they firstly fall under Faraid or no? And secondly, what options are there for individuals who have children from non-Muslim marriages or who are married to non-Muslims and who have converted to Islam but their parents were non-Muslim? So how would they ensure that these individuals receive assets from them in the event of their passing?
Right. So basically, if we have to look back at what my brother Ustaz Ridhwaan has mentioned and what we have mentioned earlier as well, basically the Faraidh beneficiaries are usually your spouse or those who have blood ties with you, your children, right, your grandchildren, nephew, brothers, depending on the family nucleus, of course, right? But at the end of the day, they must be a Muslim, right? So if they are not Muslim, then they will not be a Faraidh beneficiary. But you may be able to still dispose of or give them something, right, by way of the 1/3. So you can exercise, your right to give away 1/3, right, by way of a will. And, so I think a lot of people have this misconception as well that the 1/3, right, is only fixated to like maybe one person. You can actually give it to multiple people in equal shares, but so long as it is still within that 1/3 of your total asset, right?
And is the other option if they give it as a gift before they pass away? Is that another option that are available to them?
Of course, if you are still alive, then the property belongs to you, right? So, for example, if I have my handphone here now, right? So, if I just want to gift it to our dear host here, right? So that becomes hers, right? Now, as of now. So, it won't form part of my asset anymore once I pass away. You see, because I've already given it to her. The object has moved from me to her already.
So ownership has changed.
Yeah, the ownership has changed. That's right. Of course, there are other ways as well for you to give to such persons, right, who may not fall under the Faraidh beneficiary. So another way is by way of nomination, right? So if you are to have your insurance, make sure, to nominate and provide your nomination to your agents as well. So those are covered. And for CPF, make sure to log into your CPF through your SingPass. Nowadays, government has made it so much easier for us to, access all these tools, right? You can just go log in through your SingPass, click on CPF icon, and you are in it, right? And then you can just list out who are the nominated persons, right, that you have chosen. And that's it. It's as easy as that, right? So if you are to nominate them, then it won't form part of Faraidh and it does not go against Faraidh as well. Right?
Okay.
So no issue there.
Okay, thank you. Ridhwaan, based on your experience, are there any practical challenges to be mindful when planning for your lawful heirs as well as your children that don't fall within Faraidh?
Okay. So I think, for example, if you have adopted children, right? If you have adopted children, or let's say one of your children goes out of Islam, or maybe your one of the child goes missing in Singapore or even overseas or something, right? So if we look at the default for the first one, if it's an adopted child, then you can do Wasiat or the Wasiat. Or you can also do, for example, Hibah. You can also do trust for the child. Okay, and if it's joint account or joint tenancy also, is the rightful survivor will get it. When it comes to the child who goes missing, for example, so there are some cases that we have seen where the child goes missing, but he's still in Singapore. I think there's a process Number one is you have to go to police, and then after that, because at the end of the day, if you don't plan for it, right, then he has a right to the property even though he is missing. So number one is that you have to go to the police and make an advertisement, and then number two, there's 4 steps. I apologize, I cannot remember all 4. If only I had the slides on it. But then at the end of the day, MOM, is he still working in Singapore? ICA is still in. Is he working in Singapore? ICA is he still in Singapore? Police make an advertisement. I think there's one more I forgot. But nevertheless, he will still have a right to the property if you don't plan for it, because it's a default. The default option is Faraidh. Okay, the number 3 is if the person leaves Islam, right? Then, as Brother Ezra mentioned, he doesn't have a right to the property, so to the estate, because he is not Muslim anymore. But of course, as a form of mercy to the child, then you could perhaps give a hibah to him, a gift. Okay, maybe this is for you, for all the days or all the years that you have cared for me or something. Yeah, so these are the things. Hope I'm answering the question.
Definitely, yeah. There's also for Ezra, on an alternative tool that we haven't touched on yet, which is LPAs. Are they recognized?
Yeah, I mean, LPA is recognized, right? In fact, I mean, those of you who are intending to do your LPA, right, it's a good time to do it now, right? So registration is free with the ministry, of course, the relevant ministry, right? Up until, if I recall correctly, it's up till March 2026, right? So if you do wish to do your LPA, now is a really good time, right, to do it, because the administration fee is waived off, right? But of course, you have to still pay for the person certifying the LPA, such as the doctors or lawyers, and that differs from one practice to the other, right? So I mean, you can ask around, yeah. But one thing we need to just to remind, those who are listening as well. So the lasting power of attorney, there's been some misconception as well, that if you have an LPA, then there's no need to do a will. Now, this is not correct, right? Because if you have an LPA, it only takes effect when you lose your mental capacity, and it stop having that effect, right, upon death. And upon death, if you have a will, then the will takes effect. Or if you don't have a will, then the Intestacy Act kicks in, right?
So that means that if you have a will and you've also had an LPA whilst you were surviving, your will override whatever's said in the LPA, or?
Oh no, because the lasting power of attorney, right? I mean, it's only for specific things, right? For while you are still alive, but just lacking mental capacity. So it's just to look after your welfare, where you stay, who you stay with, what do you eat, who get to decide what you eat, right? Or maybe during Hari Raya, if you want to make sure that your grandchildren or nephew and nieces get their Hari Raya green packet, right? Then you can put inside your LPA that you allow maybe X amount of money, $5,000 per year, to be taken from your account to do all those things, right? The gifting and all that, right? So it's it's limited. Right, of course, there are broader LPAs as well, which we can do, but usually, what is encouraged is the just the normal one, the basic ones, right? Yeah, but upon death, it stop taking effect, and then the person you appoint as an executor in the will take over, right? It does not necessarily have to be the same person. So you can appoint someone to take care of your needs while you're still alive, but lacking mental capacity through the LPA, right? And then you can appoint someone else who you think is more savvy, perhaps, right? Or who is able to command the respect and also the attention of everyone in the family, because each family differs, right? Yeah. So if he's able to manage the family, and then you think he's a suitable person, then you can definitely choose someone else to be the executor named in your will. So no issues with that, right?
Right. Okay. So there's a really interesting question which maybe we should have covered at the start, which is who implements Faraidh law?
Right. So if you are to look at the Administration of Muslim Law Act, which we have shared on the slide earlier, so as mentioned, Section 111 and Section 112 is very clear that for Muslims who died intestate, for Muslims in Singapore, right, who died intestate, the Faraidh principles applies, and of course the school. When I say school, right, I'm talking about the Muslim school of jurisprudence, right? So Shafi'i, Maliki, Hanafi. I won't go into all that because there's a totally different and big topic, and I'm not able to answer that question Perhaps Ustaz Ridhwaan will be able to do that, right? Yeah. But then when we look at it, the Administration of Muslim Law Act has already confirmed, right, statutorily, that Faraidh law does apply in Singapore. So no question as to that. That's the reason why when we pass away as Muslims, right, then you will have to first go to Sharia court to get your inheritance certificate done up. But the process thereafter still follow the civil law for your grant letters of administration or grant of probate. So you still then have to apply through the Family Justice Court for those grants mentioned.
Okay. And so that's the only additional step that you would have as a Muslim when you need to enforce Faraidh. There's one other question that's come through that maybe kind of falls with that, which is, if you've not got a will in place, is it Sharia law that applies by default because you are a Muslim, or is it civil law of Singapore?
Right. So as mentioned in my earlier slide, right?
Yeah.
Perhaps you did not get to see it. So basically, as mentioned just now, Section 111 and 112 is very clear, right? So if you die intestate, Faraidh law still applies to you, right? So the Intestacy Act does not apply to you.
Yeah. Thank you. We've got a lot of questions around examples of how it would work under Faraidh law. So maybe we can talk through some and both of you can tell us how it would work. So if an individual is deceased, the husband dies, and there's a wife and a daughter left, there's no will, how would Faraidh apply in that situation?
Maybe just to help answer the question first, because that is a very broad question actually, right? First, you have to determine whether or not the deceased person's parents are still alive, right? Or his brothers and sisters, are they still alive? Because if they are still alive, then they might be part of the Faraidh beneficiaries in the absence of a son, right?
Right.
So if there's, usually, right, if there's a son in the family nucleus, right, then it will cut off your brothers and sisters, say for your parents. Yeah, so your parents will still get it, your spouse will get it, and then your son and daughters will get it. But if let's say you have no sons in the family, then you need to take a look at the deceased parent, whether the parents are still alive, whether the brothers and sisters are still alive. So,
Right.
there's really a lot of way of looking at it depending on the family tree. That's the reason why we have provided the Sharia inheritance calculator link, right, for you to try it on your own, and then you will see that, there's it will definitely give you different results based on the relationship with the deceased.
Ridhwaan, is there anything else you'd like to add from a practical angle?
I think Brother Ezra has mentioned quite clearly. He has given the slides. I think if let's say, I think this is a case of where the father has passed away, right? Then the wife is the only surviving beneficiary, right?
Daughter.
A wife and I think we just discussed about this just now, where if there is no male beneficiary or male heirs, then the remaining amount will be given to the Baitul Mal, right?
Yes.
So that how you view the Baitul Mal, there's still a right of the Baitul Mal, and it's still ordained by God. So if you want to block it, then you're basically going against the divine ruling lah. That one is between you and God. So when it comes to when it comes to the Faraidh calculator and Wasiat and whatnot, so again, check with your whoever is still alive. For example, you have what Brother Ezra mentioned, the grandfather, uncle, grandson or something. Yeah, so this may also lead to them having a right to the beneficiary, or to the estate, sorry.
There's another question. If a woman was a Muslim at the time of the husband passing away, and as a result, Faraidh applied to the 2/3 that she got, and as a result, she got her entitlement, but she subsequently renounces Islam, what is the consequence? Is there any consequence in relation to the assets that she received as a result of Faraidh?
I think this is very not I mean, not those usual questions that we get, right? But I mean, if you were to ask me, then it might be difficult to claw back what you have already given, right? Because when at the point of the application of the inheritance certificate, she was a Muslim, right? So then she is entitled to it. But maybe 5-10 years later, if she were to renounce Islam, then how do you determine like how much it was to give back? Because it has already been given, right? And in any case, any estate disputes and all that, there are limitation periods as well in Singapore. I believe it should be about 12 years, if I recall correctly, right? So the limitation period is 12 years. So if you have any disagreement in relation to how the property were or the assets were distributed or disposed of, you can go to court. Of course, this is not encouraged, right? Because I mean, I do believe that when we are talking about estate matters, it's really it involves families, right? And at the end of the day, that's something that money can't really buy, right? Yeah, you can receive X amount of money from your inheritance and all that, but the kinship that you have with your family members, that is priceless, and no amount of money can be placed on it. So it's always advisable to try to amicably resolve all these issues and try to talk things out and try to just resolve it peacefully without going to court.
Yeah, agreed. There's one other question in relation to the family dispute and also the link you had shared around how you can find the breakdown. One of the questions is around where your father was previously married and you no longer can find those children. What happens? Does that mean that if you can't find them, that everything comes to a standstill and you can't access the assets of the will based on the breakdown?
Right. That's a very not typical question as well, right? What if, right? What if
Right.
your
I think we need
your
you need to caveat that this is not legal advice, and if you need specific legal advice, we do recommend you speak to your
right. I mean, but basically, I mean, just generally, right? I mean, it's difficult for us to ascertain if a deceased person has actually married overseas, right? If they did not convert their marriage, right? I mean, at ROMM, then ROMM won't have records of those marriages overseas, right? So who's to say, right? But if you know, okay, let's just look at the process. When you apply for the inheritance certificate through the Sharia court, right, you have to list out the list of possible beneficiaries. So if you think, right, or if you are aware that there are maybe one or two brothers, which you may not have seen, but you have heard, right, then you will need to first try to get their identification number and all that, because otherwise, right, the Sharia court system will not allow you to click on and go to the next step. You need the name, full name, as per passport or NRIC, and you will need their identification number, NRIC or passport number. If you don't have these two numbers or these two particulars, right, then you will not be able to move on to the next step, right? But that is not to say that you are unable to proceed on to the next step, because if after going through all those investigation on your own and making all, doing your due diligence and trying to find out all those information, you believe, right, strongly that no such person exists, right, then that's fine. So when you are declaring the Faraidh beneficiaries in the inheritance certificate, right, the Sharia court will actually send you, you need to swear, right, before a commissioner for oath, a statutory declaration stating that these are the beneficiaries that you are aware of.
Right.
And this is also to cover and protect yourself as well in the event that maybe one fine day someone from Thailand or somewhere, right, come to Singapore and say, oh, I'm your brother. Then what happened to my property, right? Yeah. So I mean, of course, if the estate still have money, then you should do the right thing, I suppose, right? And give it, because he does have a right to it according to Islamic law, right? If he is a son, right? But otherwise, you don't have to, for lack of better word, right? You don't have to kill yourself to go and find like who is missing and who is not and whatnot, right? I mean, there will be no end to it.
Thank you very much. I'll just pass on to Ridhwaan. There's actually a question that goes back to some of the claw elements, which is, how does the CPF nomination work?
Or the CPF nomination?
Yeah, and like, as in, so how do you take advantage of CPF nomination? How do you take advantage of that tool?
Okay.
When you're subject to Faraidh? Yeah,
Okay,
exactly.
understand. Okay, so I think So you know that your beneficiary for your Faraidh is a set. So in a sense, you can work backwards. So because your CPF nomination, your insurance nomination will not form part of your Faraidh, nor does it form part of your Wasiat unless you don't plan it out. Okay, so when it comes to early planning, what you can do is, for example, if you have, let's say, a best friend that you want to give some money to, a special needs family member, or someone, or your wakaf that you want to reap the benefits of when you pass away. So all of these can be planned early. So what do you actually want to do when it comes to your intended beneficiary, not the default beneficiary, but your intended beneficiary? So both your CPF nomination as well as your insurance nomination, you can do whatever you want, because it's going to be based on the fatwa by Muiz, is a new form of hibah. It's a new form of gift for the beneficiary that you intend to, not your Faraidh beneficiary, but your intended beneficiary, your maybe SPCA, Wakaf Masyarakat Singapura, maybe donate to me, or just kidding, yeah. Okay, if you want to nominate me also can nominate us, yeah.
This is not illegal advice at all. We've got another question, and I think we covered it during the talk as well. But just so that everyone's understood and goes away with the right understanding around Faraidh and who is covered by Faraidh, maybe both of you could talk through who are genuine beneficiaries under Faraidh and who is excluded.
Right. So, I mean, basically, the question is asking if illegitimate children will be part of your valid Faraidh beneficiaries. No. For children born out of wedlock, I think the law is clear. They do not form part of your Faraidh beneficiaries, but you may give them from your 1/3 of the entire estate that you are allowed to give, devise, and bequeath. Right. So that's one way of doing that. Another way for an illegitimate child or children born out of wedlock to receive from the estate is by way of nominations, by way of your CPF nomination or insurance nomination, as what Ustaz Ridhwaan has also mentioned earlier on.
And I think you mentioned also previously that if it's a child who is not a Muslim essentially, or from a previous marriage where the mother was not a Muslim, then in that case as well, it would be from the 1/3.
Yes, that's right. That's right.
There's a really interesting question, which is, maybe both of you can consider it and give me answers. Which is, what happens if the husband passes away, the wife is a Muslim, but then she gets married again and has more children? Would the assets from the husband who passed away and which she received as a result of Faraidh now also be shared with those new children, the stepchildren, essentially, when she passes away?
Right. Perhaps if I can answer the question first. I mean, I think we kind of like already touched on that topic already, right? Or on that question. So basically, right, I mean, the distribution of the asset takes place at the time of the application of the inheritance certificate and the grant letters of administration. So once these assets move to her, then it's her assets 100% already. So how she deals with it, or even if the previous spouse, right, that you were talking about earlier, right? So even if her assets now comprise of or includes the ex-spouse, right, who is deceased, it doesn't matter, because now she can do what she wants with it because it's hers 100%. So no issue. So, the other beneficiary from the previous estate cannot come and claim and say, oh, because she passed away now, we have a right to claim what she hasn't used. How do you know how many amounts she haven't used and all that? Because the assets have all intermingled and all that, right? So once the property or the assets have moved from one hand to the other, it belongs 100% to that person.
Does it also apply that if the child is no longer a Muslim, but the mother passed away and she is still a Muslim, that child who has renounced Islam would not be eligible under Faraidh as well, right? Because the child is no longer a Muslim.
Yeah, so for at the point of death, if the child is not a Muslim, then the child will not be entitled to the assets of the deceased, right?
Yeah.
Say for if you have gifted from the 1/3 by way of a will or by nominations.
Okay.
Yeah.
Ridhwaan, is there anything else you'd
I
like
think if I may add, one other ruling is that besides him or her renouncing Islam, and then you cut off the ties that you won't get at the estate, right? Is also the murderer. So if let's say, yeah, now we all know. Okay, so the murderer also doesn't get. Okay, so that is one of the rulings lah. So if the son murders the mother or the mother or the father, then he or she he won't get the Faraidh monies or the estate. Yeah.
Okay. There's a follow-up question to Ezra's point around using the calculator. The question is that Faraidh is determined by the person who's putting in the names. Is that correct?
Yes, I mean, it is determined by the person who is putting in the names, but don't forget, as what was mentioned earlier, right? The person who is putting the names in the Sharia court calculator in order to obtain that Sharia inheritance certificate has to do it and declare by way of a statutory declaration that whatever details provided is true and correct. So if she or he have not acted wisely, right, and tried to defraud a beneficiary by not including the beneficiary name inside, then basically there's a criminal offense really, because if you lie, through a statutory declaration, right, number one, that's a criminal thing, and at the end of the day, if the beneficiary comes after you, then that's another thing that you have to deal with, civil suit after that. So you have a criminal suit and a civil suit that you have to deal with at the end of the day. So please don't do that.
It's not worth it.
Yeah, it's not.
There's one more thing, one more question. So under Faraidh, the son receives assets. What happens if your son is actually a bankrupt and you don't want your son to receive these assets, because then the creditors will come after those assets when in the event of your passing? Is there a workaround? No.
I mean, as far as I know, I mean, just based on these small facts, right? There is no workaround around it, right? I mean, he's entitled to his estate, of course. So, I mean, at the end of the day, it will become part of your assets, really, right? So, if you owe something, then you have to make payment for those things. Then, unfortunately, then you have to clear off those debts, lah, right? Because now you have the assets to clear it off, right, and start fresh. Maybe that's one way of God giving you a second chance and opportunity to start fresh.
Thank you. I think there's I'm just trying to make sure we've covered everyone's concerns. I think we covered this one about the children, yes. If you've got more questions, we've got a bit more time, so if you'd like to talk through some, but maybe Ezra, Ridhwaan, from your experiences, you can talk through some of the unique situations you have seen in practice and as well as financial planning.
Yeah, maybe if I can start first before I forget, because I'm more forgetful than Ustaz Ridhwaan, right? Yeah. So anyways, right, I mean, just, so I was looking through, some of those questions earlier. I did notice one where, the person asked if if there's a divorce, right? Then what happened to the deceased spouse share in the flat, right? I mean, it does happen at times, right? So let's say there's a Sharia court order already determining that the assets are to be split in a certain way, then even though your spouse may pass away later on, thereafter, right, after the court order has been made, then the share that was determined by the court still has to be given to the estate of the spouse that has passed away. I mean, that's the long and short of it. Right. So I hope that answers the question if we have overlooked it earlier.
Ridhwaan.
I think from the recent event that we had with Muiz, right? When, let's say, a person comes in to our table as an asatiza consultant, they come with not the stories and all, but they also come with emotions. I mean, we cannot do anything much besides what the rule of law, land of law of land, is it? Law of the land. Yeah, I forgot that. Okay, law of the land states, as well as what the Quran states. So, example, you may want to argue that your brother didn't. You are a daughter and you have a brother, but your brother didn't take care of your parents, and then after that, now you want to take at least half on just equal share, right? Because you know that the rightful amount is that you will get lesser. Now, that ruling where the male heirs get more is not just because maybe you can say males are better. No, it's because the males have to take care of the female. They are protectors of the female. So that's why, for example, if I can just go back to the history of Adam and Eve, right? Eve was based on Islam,
Yeah.
Eve was taken from the rib cage or the bone where on the rib cage when Adam was asleep. So it's a sign that if the males are supposed to protect the female, not just that you have more wealth, you have more estate, but then you don't take care of it, but rather it have to take care of your female beneficiary. And if I can move on, and you can cry all you want, and I mean I can feel sympathy for you, but I cannot change anything. Nor will the hakim or the judge can change anything. Yeah, that's what I can say. Yeah.
Thank you. Ridhwaan, there's a question that's come specifically for you.
Okay, yeah. Oh, no, because
It sounds like our listener is very frustrated at the minute with
first it over here.
with the parents not wanting to use any of the tools we've been talking about. Is there any way that they can convince? Because essentially it sounds like they don't believe that it's allowed under Islamic principles.
Right.
Yeah, other than for Faraidh, the alternative tools that we've discussed. So is there any way that this child, she's essentially the child of the parents, can convince her parents that there are other Islamic tools, that other tools that are recognized under Islamic principles in addition to Faraidh that they can consider?
I think we actually did discuss this earlier. The last time when we were the Malay community, they usually what do you say just now? The Malay community usually leave it to the elders. Malay custom.
Malay custom.
Leave it to the elders,
Correct.
and then distribute it to who to his whims and desires. But the ruling is there. It's a divine ruling, so that you cannot argue again. So okay, that's Faraidh, that's Wasiat. Then of course there's Hibah. Now all of these have their own sources. So example, for Hibah, it's a gift, and the Prophet Muhammad SAW said that give to one another, gift, give to one another, so that you may love one another. So that is one aspect of estate planning tool that you can have. Now there's Hibah Amanah, which is under trust. Then after that there's Nuzriah, we won't talk about it. Okay, so sorry, we won't talk about it. Okay, Nuzriah is there. Then of course there's Wakaf is there. And so Hibah, trust, Hibah Amanah. Then after that your Wakaf, your Wasiat, and then after that your joint tenancy or joint account. So all of this, joint tenancy and joint account, of course, there's a fatwa on it that the surviving spouse has the rightful share. But if you look into the terms, right, when you open a joint account, there is a term that the surviving person will receive the surviving amount or the remaining amount that is in the bank account. So yes, you may disagree with the Sharia ruling, but you also still agree to it in the terms and conditions. So so in a sense, if you want to know further, you can of course talk to Brother Ezra, or if you want to know further, you can go to Muiz, and then lastly go to me lah. Last resort. Okay.
So that you got your answer, the order in which you can go and get your advice from and get support. We've got another question around assets and knowing exactly how much is available under Faraidh when someone has passed away. So how will you know the total value of assets that are available under, total value of assets that are held by the deceased?
Right. So basically, upon the application of the grant letters of administration or grant of probate, right, there's a step that needs to be complied with, which is the schedule of assets. So the lawyers that you have appointed will naturally then have to be instructed to write to the banks in order to find out as much as possible what are the assets that's lying around in Singapore, right? I mean, to the best of your abilities, right? Once you receive those information, then it will be imputed inside this form called the schedule of assets, and then the court will endorse on it, right? Then it will give you the total amount, right? From the cars to house, right? To bank accounts. Those things that are not to be included inside will be those held in joint names. So if it's bank accounts held in joint names, then those will not be included in the schedule of asset. If the HDB was bought in joint names as well, the HDB flat will also not be included in the schedule of assets, save if that deceased person is the last survivor of that joint accounts. Then yes, then you will have to put those inside the schedule of assets. So that's one way of figuring out and getting the total amount of assets that the deceased may have, which is by way of that schedule of assets.
And is it limited to assets that are in Singapore, or would you, if you have assets elsewhere outside of Singapore?
It's not limited to assets held in Singapore, right? You can also include assets held overseas if you are aware of it. But for those cases, I mean, the Singapore lawyers like me, we won't be able to check for you. Then you will have to get the lawyers overseas or an agent overseas in order to help determine the bank accounts or the properties held in those. At overseas, right? Yeah.
There's one other question around Faraidh legitimate beneficiaries. Is in relation to gender, it's as per it's based on what's recognized under the laws of Singapore, right?
Yeah. I mean, because for Faraidh, I think the question comes about because of the supposed maybe in the sense that the son gets two parts, or the daughters have just one part share, and then the daughters supposedly is the one who usually takes care of the parents, right? And then the brother is not doing anything else. I'm just giving an example. This is just fictional, right? Okay, I'm not pointing to anyone or anything, right? Okay, right. But I mean, at the end of the day, right? First we will have to follow the law, right? So the law dictates that we have to distribute all these assets according to Faraidh in a certain way. Now, at the end of the day, upon receiving those assets, if I have seen families, right, who actually comes together, brothers and sisters, who agrees on, hey, you know what, maybe we don't have to follow this Faraidh distribution method, right? After we receive our share, we just, pool again, and then we just divide it equally among ourselves. I have seen that happening, right? So that's actually one way of doing it. It doesn't mean that you are given it, then it's yours. Oh, so that means to say Faraidh doesn't allow me to share what I receive with my siblings. It doesn't work like that, right? In fact, you receive it. If you want to give it or you are able to give it, you have that ability, then yeah, why not, right? Then share it equally. Then at the end of the day, as what I mentioned before, right? If that helps to save in Malay, we will say silaturahim, right? Right, the kinship amongst the family members, then yeah, why not? But of course, to each his own. So this is something which has to be determined and decided by that person involved.
Thank you. We still have a bit of time if you want to submit any more questions. We'll talk through one final example that was put forward, which is if you are the husband that's surviving and the wife has passed away and you've only got 2 children left and they're both male, there are no parents, there are no siblings, how will the assets be divided?
Yeah, I mean, if there's no longer any parents, right? The deceased parent is no longer around, no brothers and sisters, it's just the 2 sons, right? You're saying then basically the sons will take all equally.
Okay.
Yeah.
But how if there was a daughter and a son left? How would that work then?
No, then as mentioned, the son will take 2 share and the daughter will take 1 share.
Right. Okay. I think we've covered all the questions that everyone had, and we've talked through quite a few examples. Are there any last thoughts that you'd like to leave the audience with? I'll first go to Ridhwaan, and Ezra, I'll let you think of something while we go to Ridhwaan.
Okay, can. I think if I can just recap what we discussed, right? Because I think the questions all generally they are quite the same. So number one is for you listeners, puan-puan and puan-puan di rumah kan, at home, ladies and gentlemen at home, just if you want to take action today, number one is perhaps remember clause square, so CPF, LPA, AMD, ACP, as well as your wakaf and your wasiat or your will, or the other way around. Then after that, if you still don't want, I don't want to handle my asset because I don't know how to determine the asset properly or who I should give, right? Then that's where you approach your financial advisor as well as a lawyer. So the lawyer and financial advisor can see that you distribute your asset properly, as well as you mitigate any risk of conflicts between your families when you pass away. And perhaps lastly, use deliver a last letter for your loved ones, whether it's a recording like this or whether it's a written letter, a reminder of what to do. For example, take care of your take care of your sister, take care of your mother. So that could be the last letter reminder to your living beneficiaries that don't just take the wealth and then we are done, but rather take take heed of what you want to remind them of. Pray, do the zakat, the alms, and then after take care of one another. So as mentioned, Brother Ezra mentioned silaturahim, right? To take care of your kinship, your ties of kinship, and that is very important in Islam. Yes. Okay. Thank you.
Ezra.
Yeah, I mean, I'm just gonna be repeating myself over and over again. But I think a lot of people are wondering as well, right? At the end of the day, I mean, since Faraidh have already predetermined the shares to be received by the beneficiaries, so why do we still need to take the trouble to draft a will? Because you believe that my children understand me, so it's okay. I don't have to draft the will. They will know what to do, and they will be able to sort it out amongst themselves. Well, I mean, from my experience, I have seen things doesn't really turn out, a certain way as much as we expect the best of our family members. So, even though there are predetermined shares already, as mentioned just now, from, Ustaz Ridhwaan as well, he mentioned it as well. If you draft a will, as mentioned, you will be able to appoint the person you trust who can manage the expectation of family members as well, right? To distribute all those assets that they to be received. So that's number one. Then number two, you can exercise your wanted as well, as what Ustaz Ridhwaan has mentioned as well. At the end of the day, when you pass on, right, just like the example of the Prophet's friend that you have given about the well, right?
Yes.
The currency is ongoing, right, up until the end of time, right? Yeah, so that, I mean, there's something that the community can consider, by exercising the wanted and giving it to Wakaf Masyarakat, or maybe to a specific mosque or to a specific orphanages. I mean, it's entirely up to you, of course, so long as they are charitable causes, which will help you at the end of the day, right? In your religious duties, right? I mean, at the end of the day as well, even if, right, things doesn't really turn out the way all of us expect it to be when it comes to the distribution of assets, as mentioned, I really do hope that family members can discuss amongst themselves if it's possible. I mean, of course, you can distribute it equally if that's the intention of everyone, right? No problem to that. But if that doesn't come about, then you cannot force it, right? So even if you sue that person, because I have some cases where they say that, as a daughter, I'm the one who take care of my mother and father. Well, they are still around. My brother didn't do anything, so now I'm going to sue them for an equal share. I say that's not possible, right? Because Faraidh principles are Faraidh principles after all, right? Right? Okay, so you will still have to be satisfied with your 1-part share, and your brother will still receive the 2-part share. If it is within his conscience to give it to you, because he think you should rightfully receive slightly more, then that is entirely and solely up to him. There is no obligation whatsoever for him to give his share of the estate to you if you are not entitled to the same, right? So I mean, that's all I can say for tonight.
Thank you so much to both Ezra and Ustaz Ridhwaan. Thank you. Given some of the questions we had, I feel like it's important to reiterate that this wasn't intended to substitute any form of professional legal advice. And if you do require any specific advice, please do reach out to your legal advisor and make sure you've provided all the information, because we're going off whatever you've provided here and we're talking hypotheticals. So please do be conscious of that. So thanks again to both our speakers and to our audience for joining us today. We have to bring this Q&A session to a close at this time, but our next webinar will be Cyber Hygiene, Know Your Rights and Responsibilities Online. It's happening on Wednesday, 16th October 2025 at 7:30 p.m. The session will explore common cybersecurity pitfalls, new data protection challenges in hybrid work environments, and how to respond to security incidents. Whether you're a consumer, employee, or business owner, you'll walk away with a better understanding of your digital rights and how to protect yourself online. This and many more webinars are part of Law Awareness Week at CDC 2025. You can click on the link shared in the chat function to visit the website to register for the next webinar or the many more webinars available. If you missed any of the webinars and wish to catch the ones you missed, The recordings of all the Law at CDC webinars will be made available on Pro Bono SG's YouTube channel 2 weeks after the end of the live webinar. You can check out the link shared in the chat function. Also, it gives you the opportunity to share it with anyone else you feel needs to understand what are the tools available. If you missed clicking on any of the links shared during today's webinar, don't worry. All links shared in today's webinar will also be provided in the follow-up email that will be sent to you tomorrow. Do look out for it. After today's fantastic sharing from our panelists, if you find that you require legal guidance on your legal issue, do write to help@probono.sg. And lastly, we would like to express our gratitude to both Ezra and Ridhwaan for sharing their knowledge and experience with us. With that, on behalf of Pro Bono SG, we would like to thank all of you for joining us today and have a good week ahead. Good night.